In 1995, the international law of patents changed dramatically. That was the year in which the World Trade Organization agreement on trade-related aspects of intellectual property rights, known as the TRIPS Agreement, came into force. The TRIPS Agreement introduced minimum standards of protection and enforcement for all types of intellectual property rights. But its implications were particularly profound in terms of patent law. By the time that the transitional arrangements for implementing the TRIPS Agreement came to an end in the year 2005, with the exception of a small number of the world's least developed countries, all WTO members were required to make available patents in all fields of technology. This meant that countries such as India and Brazil, which had previously excluded pharmaceutical product inventions from patentability in order to ensure that cheaper, high-quality drug products were available to the public, could no longer do so. The price and availability of medicines increased significantly as a result. Elsewhere, farmers' rights began to be eroded as a result of plant breeders' rights on cultivated agricultural products, while indigenous and local communities found that their traditional knowledge over genetic resources used for traditional medicines started to be subject to patent applications by multinational companies. This module on the international law of patents examines these controversies in detail. It looks at the inbuilt safeguards in the TRIPS Agreement and also in the Convention on Biological Diversity and other international agreements in order to assess whether countries around the world can implement their international patent law obligations in a manner that is conducive to the public interest of their citizens. The module takes the form of 10 three-hour lectures, which are all taught by me, and these are supplemented by small group teaching, adapting a case study approach. Special focus is given to the role of patents in the development of vaccines during the COVID-19 pandemic, and to traditional knowledge, and to farmers' rights. Many of my former students from the module now work for international organizations, such as the World Intellectual Property Organization in Geneva, where they put their knowledge into practice. The assessment for the module is by means of a 5,000-word assessed essay. Students are provided with a list of essay topics covering different aspects of the module, and they're free to choose one of those topics for their assessment. No prior knowledge of patent law is required in order to enroll for the module.